Justice Velasco.
Counsel, can you clarify what is your position on what family planning methods are to be outlawed, or any provision on that will be declared unconstitutional? Will this be family planning methods that prevent the fertilized ovum from implantation in the maternal womb, or do you want a provision that allows distribution of family planning methods that prevent fertilization of the ovum? Can you clarify your position on this?
Well, definitely, Your Honor, we cannot allow, we will resist, we will object to the propagation of abortifacients. Now, with regard to...
But that's in the law. That's
in the law, yes, Your Honor.
It is prohibited, right?
That's correct, Your Honor.
Okay, so what's your view, your position on the other query? Whether a provision that allows distribution of family planning devices or drugs that prevent fertilization of the ovum should be declared unconstitutional?
Yes, Your Honor, because first, as we've mentioned, even contraceptives, meaning those that are not abortifacients, pose some risk to a woman.
Counsel, and give me first a categorical answer. Are you asking the court to declare a provision that allows distribution of family planning devices or drugs or other methods that prevent fertilization to be unconstitutional?
Yes, under Article 2, Section 15, the obligation of the state to protect the health of its people, Your Honor.
Is that contained in your petition?
Yes, Your Honor. That's correct, Your Honor.
So this is a different position than that taken. Sorry. Please correct me, but I think Attorney Noche made a different proposition when she made her presentation. So you have a different proposition now. So you are saying that all these family planning devices, drugs, and methods, or any provision on that allows distribution or use to the people has to be declared unconstitutional. Is that your position now?
Yes. Our position is that even contraceptives, the propagation, if it is especially state-sponsored, as it is in the RH law, will violate the duty of the state under Article 2, Section 15, to protect the health. It will also violate Article 2, Section 12, which requires the state to protect equally the mother and the unborn from conception. So, in other words, what we're saying is that, yes, even non-abortifacients, because of the fact that they pose health risks to the women, will have to be objected to on the ground of Article 2, Section 15, and Section 12.
No, we are referring now to non-abortifacients because you admitted that abortifacients are prohibited under the RH law, and so there's nothing wrong about that. Is that correct?
Yes, it's prohibited. Yeah.
All right. So we're now talking about non-abortifacients, and your proposition now, although I'm not sure if that's really contained in your prayer, is that this provision that allows distribution and use of these non-abortifacients that prevent fertilization of the ovum should also be declared unconstitutional.
Yes, Your Honor.
Is that clear now?
Yes, Your Honor.
Okay. Then, practically all family planning, drugs, devices, and methods covered by Section 7 will have to be outlawed. Practically all. Right?
Since they are harmful, yes, Your Honor, because that will violate the duty. Our main point is this, Your Honor. These non-abortifacient drugs are available in the market. But what the RH law does is for government to be the initiator, to be the prime mover, to be the financier. It will buy, it will distribute, it will promote these contraceptives to the population. And we are objecting to that because that contradicts Article 2, Section 15, which clearly obligates the state to protect the health of the population.
So is your view that if it is the government that will distribute and supply these family planning methods, then that should be declared unconstitutional?
Yes, Your Honor.
But if it will be private groups, NGOs, or private persons, like the Condom King in Thailand, that's okay.
That's okay because there's no prohibition for a private individual.
As long as these are non-abortive patients.
Yes, Your Honor.
Okay. So, on that premise, you're saying Section 7 should be declared unconstitutional because it is provided there that all accredited public health facilities shall provide a full range of family planning methods, right?
Yes, Your Honor.
That is your basis.
Yes, Your Honor.
You're aware of the administrative code, right?
Some
Are you
of it,
familiar
some
with that?
provisions, yes.
Are you familiar with the duties and functions of the Department of Health under the administrative code?
Little bit of the enumeration probably, yes, Your Honor.
Yeah, I'm asking you about that because if Section 7 will be declared unconstitutional, then necessarily Section 3, Item 2, in Title 9, Chapter 1 of the Administrative Code on the powers and functions of the Department of Health may also be challenged as unconstitutional. And I read to you that particular function of the Department of Health. And it says, the department shall, and this is Item 2, provide for health programs, services, facilities, and other requirements as may be needed, subject to availability of funds and administrative rules and regulations. So even without Section 7, the Department of Health can distribute these family planning methods. And as a matter of fact, the department may have been doing that. So, with the declaration of nullity or unconstitutionality of Section 7, this may lead to an examination of Section 2, or rather Item 2, Section 3 of Title 9, Chapter 1 of the Administrative Code as also unconstitutional?
Your Honor, from what I heard, that provision speaks of health products. Our position is that contraceptives are not medicines. They're not medicines. Their reason for being is not to cure. If there may be incidental effect of curing, it's only incidental. Its main and only purpose is to avoid pregnancy. It is not treating a particular illness, Your Honor. So I think that provision may not be related to our position that the RH law violates Article 2, Section 15 because that provision obligates the state to protect the health of the people.
So you're trying to harmonize the
Yes,
two
Your Honor.
provisions.
Yes, Your Honor.
So we can declare unconstitutional Section 7, but under Title 9, Chapter 1, on the powers and functions of the Department of Health, it is not supposed to distribute family planning methods, right?
Yes, Your Honor.
So what the Department of Health is doing right now, which I think is the distribution of these family planning methods, contraceptives, and other supplies, may be unconstitutional. It may also be challenged. Is that correct?
Yes, Your Honor. If they will distribute the same way that the RH law will obligate the Department of Health to distribute to the poor, I think, yes, they will run afoul of Article 2, Section 15 of the Constitution.
Well, of course, this is offered to all walks of life. People, maybe average income family, coming from average income families, or the poor, or even the rich. So, Department of Health may be really distributing these family planning methods now to the poor, right?
Right,
The
Your Honor.
marginalized. Okay. There is nothing illegal about distribution of contraceptive drugs or devices, right?
If it's done by private individuals, I don't see any problem there, provided
it's
they are
done.
not abortive actions, yes.
Mhm. Of course, we have a law on the use of contraceptives, right? Republic Act 4729.
Yes, Your Honor.
And it says that these contraceptive devices and drugs can be sold only with the prescription of a qualified medical practitioner.
Yes, Your Honor.
Okay? So, Republic Act 4729 is not in any way, will not be in any way affected by the declaration of unconstitutionality of the entire RH law?
Maybe not, Your Honor, because there are safety measures there. The condition that contraceptives shall only be dispensed with or upon prescription coming from a licensed physician might be enough safeguard, Your Honor, because the foundation of Article 2, Section 15 is the duty to protect. And that requirement for prescription might serve as the protection device.
Mm-hmm. Is it really your position that all these provisions will have, or rather the entire law will have to be declared unconstitutional?
Yes, Your Honor.
Don't you think that some provisions can remain unaffected by any declaration of nullity? Like, for example, Section 8, maternal death review and fetal and infant death review. There's nothing wrong about that.
There's
Right?
nothing wrong with that, but the Magna Carta already takes care of that, Your Honor.
So
there's
this is
no-
a redundancy, right?
Yes, Your Honor.
Okay, well, we have to look into this clearly. How about the Section 15, Certificate of Compliance for people who want to get married? Is there anything wrong about that if they are given a seminar on family planning, breastfeeding, and infant nutrition? Is there anything wrong about that? Or is this covered by another law also?
No, there's a constitutional provision that might be transgressed or infringed by that additional requirement.
So you're
Because-
saying we should not require the
Yes,
couples
because
who intend to get married to undergo the seminar on these matters?
Yes, because it creates another condition, making it difficult for them to actually contract marriage. And what is wrong with that provision is that it gives the issuing officer certain discretion, because it says he will certify that adequate instruction have been given. Adequate is a very subjective term. There is an old law actually that covers something similar, PD 956. But that law does not give any discretion on the issuing officer, unlike the RH law under Section 15, Your Honor.
I again refer to the powers and functions of the Department of Health, and under Item 6, Section 3 of the same Title 9, Chapter 1, the department has the duty to propagate health information and educate the population on important health, medical, and environmental matters which have health, medical, environmental which have health implications. So, you're saying that this does not empower the Department of Health to, or rather, the state, or rather the Department of Health to provide information on family planning methods? This will not be a sufficient basis for the Department of Health to provide information on family planning methods?
If the premise, Your Honor, is that contraceptives are potentially harmful, yes, I would think so, Your Honor, because again, it will collide with Article 2, Section 15 of the Constitution.
Are contraceptives really harmful? Or why is it being allowed by Republic Act 4729? Why is it being allowed but subject to regulation?
That's the point, Your Honor. It is self-evident. The fact that the former law, actually it's the pharmacy law, I think that is 4729. The fact that it requires prescription from a duly licensed physician tells us that it is harmful if taken without supervision, because you need to know any underlying risk factors that person might have that might aggravate his illness, pre-existing illness. I think that's a good evidence that these contraceptives could be harmful.
So, the 4729, Republic Act 4729, may complement whatever provisions of RH law that refer to contraceptives, correct? That's a possibility. So, when you give contraceptives, it has to be under the supervision of a qualified medical practitioner.
I think there is a repealing clause, Your Honor, if I remember correctly, in the RH law.
In the RH law?
Yes, so that means that 4729 might be deemed repealed because there is
being inconsistent.
Yes, very inconsistent.
Okay, but you want the entire law declared unconstitutional anyway.
It has no point, Your Honor. It doesn't serve anything because whatever good points it might have, the Magna Carta already has it.
Okay, that's all. But can you put in your memorandum what provisions here in the RH law have similar provisions in the Magna Carta?
We'll do that, Your Honor.
Okay, and that can you explain clearly also why all the provisions have to be declared unconstitutional? Because to me, my view right now is that there may be some that may remain constitutional while probably some may be declared unconstitutional. Thank you, Counsel. Thank you.
Mrs. Leonen.